which is the establishment of the governing organ of our democracy and constitutional polity. This institution, with the rest of our statecraft, emerged from within the sacrifices of our liberation war, embodying the enduring and indomitable aspirations of our people for justice, shielding against the abuse of state power and the depravity of tyranny, oppression, and injustice. Decades later, we reflect yet again on the foundation and evolution of this institution, which has once again come to embody public trust following the July Revolution, when our people revolted against authoritarianism. Indeed, the Supreme Court stands tall as a stabilizing force in times of uncertainty, and a reminder that justice must remain accessible, impartial, and resolute, even amid turmoil. Hence, this day is not merely a celebration of an institution, but a recognition of the values that sustain it, namely integrity, independence, and an implacable pursuit of justice as fairness. On such a profoundly significant occasion, it is incumbent upon us all to not only fondly remember the unfading legacy of this great institution, but also to collectively envision its future. Maintaining its robust functionality is certainly an absolute imperative, as an independent, efficient, and functional judiciary is the very essence of constitutionalism and a universal criterion of constitutional government. The Supreme Court, in its indispensable role as a constitutional court, constitutes a fundamental component within our national imaginary. Its existence is deeply rooted in the philosophical underpinning of limited state power to protect individual rights, safeguard minorities from impulses of majoritarianism, ensure social justice and peace, preserve democratic principles, and promote collective well-being. Both historically and philosophically, the significance of a constitutional court is often deemed to be linked to moments of profound political transition. Hans Kelson's advocacy for a constitutional court, although rather abstract in its theoretical formulation, in fact arose from within entrenched political polarization. Kelson believed that such court was an essential legal mechanism in order to resolve disputes, avert violence, and ensure continuous compromise between competing political factions. For Kelson, the Constitutional Court, through its power of judicial review, was a crucial instrument for the citizens, and particularly for minorities, to vindicate their rights against potential statist overreach, thereby fostering justice and stability. The philosophical basis of the Supreme Court's constitutional role is further illustrated by common good constitutionalism. This framework assesses institutions' indispensability based on their contribution to ensuring common good, rather than solely on their potential in maximizing liberty. This approach advocates for collaboration among various constitutional actors, extending beyond mere checks and balances. Each institution, legislature, executive, and judiciary, possesses a unique moral role and expertise. The democratically legitimate and representative legislature crafts laws. The executive implements laws and policies, and a skillful judiciary acts as a course correction mechanism, adjudicating individual cases and ensuring that legislative and governmental actions do not breach constitutional mandates, fundamental principles, or rights. Since its inception, the Supreme Court of Bangladesh has consistently aspired to implement the vision enshrined in our Constitution, striving to attain true constitutionalism as characterized by a fundamentally limited government and the attainment of collective welfare. This, in its normative sense, entails the deliberate limitation of state power, the prevention of consolidation of authority, and the conscientious maintenance of appropriate checks and balances. Thus, for instance, by adeptly employing the instrument of reviewing unconstitutional constitutional amendments, the court has effectively mitigated and continues to counteract democratic backsliding and deter the emergence of authoritarianism and abusive constitutionalism. Ladies and gentlemen, the Supreme Court of Bangladesh conceptualizes the power of amendment as a delegation from the people to their political representatives, conferred during the primary act of constitution making. The primary constituent power is deemed to possess the authority to craft the foundational rules of game. Conversely, constitutional amenders, or the derived or secondary constituent power, are inherently constrained to bring in only such alterations that do not infringe upon the foundational choices originally made. Across the global south and beyond, we are witnessing a disconcerting phenomenon, the weaponization of law as a means to attack political rivals by incumbent forces, often intended to perpetuate or substantially elongate their reign. In such circumstances, the polity invariably turns to the judiciary as an impartial and final arbiter, entrusted with the responsibility of undoing these attempts and protecting the foundational principles of both justice and the rule of law. Ladies and gentlemen, over the years, the Supreme Court of Bangladesh has emerged as a key actor in the comparative constitutional discourse within South Asia, striving towards a universal normativity by invoking values and principles that resonate with the global human experience, while simultaneously respecting our unique social, cultural, and contextual realities. Parts 2 and 3 of our Constitution guarantee fundamental principles and rights. Yet the contents of these principles and rights possess penumbraries that merit reflection. In examining these, both divisions of the Supreme Court have frequently drawn upon international law and principles of international conventions and customary norms. The Court has effectively bridged international legal principles and domestic constitutional jurisprudence, while also appreciating the normative hierarchy of the two within our corpus juris. Over the years, The court has deployed originalism, textualism, intentionalism in interpreting the rights provisions enshrined in the Constitution. The court's use of universal and culturally relativist norms too has had a profound impact on the growth of our jurisprudence. For instance, in Dr. Shipra Chaudhary and another versus Bangladesh, the court justified its reliance on international conventions while enforcing personal liberty from both originalist and textual perspectives. The judgment in the 2001 H.M. Ershad case exemplified the idea of, as scholars note, creeping monism, wherein the court began to consider international conventions while interpreting provisions of Part 3 of our Constitution. In Ask or Aino Shalish Kendra versus Bangladesh 2004, the court extensively relied on international conventions in interpreting constitutional rights of children in Bangladesh. Moreover, the BNWLA sexual harassment case illustrated the application of international legal norms and conventions by the Supreme Court as it referred to provisions from the International Covenant on Civil and Political Rights and the Convention Against Elimination of All Forms of Discrimination Against Women, among others. Beyond these cases, a discernible pattern emerges, where the court is found to have conducted extensive comparative analyses to reinterpret and reimagine the constitutional provisions forming part of our domestic legal order, thereby broadening the domain of, for example, judicial review. Instructive here is the Maulana Abdul Hakim case of 2014, where the court held that private bodies performing functions essentially of public nature are amenable to the writ jurisdiction in Bangladesh. In the past year, I have undertaken initiatives through my office to ensure that the Supreme Court of Bangladesh remains relevant in an increasingly interconnected world, transcending geographical limitations, intellectual exclusion, and international political dominance. I have sought to forge meaningful connections with non-traditional partners across the globe, thereby increasing interdisciplinary connectivity through judicial diplomacy. Indeed, I am proud to note that the Supreme Court is incrementally emerging as a strong and relevant constitutional court on the global stage. Dear attendees, the Supreme Court, as the guardian of the Constitution and the institution guarding the will of the people, wields substantial power. However, with such immense power comes massive responsibility and the threats of co-optation. This power renders the court quite a target for populist and authoritarian leaders seeking to capture and manipulate the state machinery. Throughout the world, in both established democracies and those navigating transitions like ours, there emerges recurrent phenomena of judicial capture, whereby the judiciary is co-opted by the executive in order to dismantle institutional checks and balances and entrench executive hegemony, and thereby facilitating groundwork for constructing and sustaining essentially authoritarian and illiberal regimes. It is imperative, therefore, that judges appointed to the apex of the judiciary not only possess merit, but also uphold high standards of dignity, work ethic, and integrity within the society. Moreover, the judiciary must remain accountable only to the rule of law. Such measures will certainly save the savior and fortify other state institutions. In this context, the reform process within the judiciary, initiated under the stewardship of the Supreme Court following the July Revolution, has played a crucial role. This includes the introduction of comprehensive legislation governing the appointment of judges and the establishment of the Supreme Judicial Council to hold judges accountable in cases of deviation. Furthermore, and unmistakably, most significantly, an independent Supreme Court Secretariat ordinance has been passed, breaking away from the long-standing dual control over judicial officers and thereby founding the bedrock for a strong, independent, and institutionally autonomous judiciary. These developments represent significant milestones in shaping both an independent and accountable judiciary committed to the pursuit of justice in the form of liberal constitutionalism. Now, as we look to the future, we must continue strengthening public trust in the justice system through transparency, efficiency, and empathy. Technological advancements, evolving social expectations, and complex legal challenges demand that we innovate and continuously improvise while holding firmly to constitutional principles. On this occasion, I call upon every member of the legal community, the distinguished judges, members of the bar, legal scholars, and citizens to work collectively toward a justice system that is not only respected, but more significantly believed in. Thank you ever so much.